Need to introduce these folks. You can see, I believe we've got names up here, so that's good. It'll keep everybody straight. But we have three folks to talk with us in this next session. And since this is about discrimination in the workplace and discrimination in general, I'm going to be politically correct as well as polite. Introduce Kerri Riley first. Kerri is a sole practitioner here in Huntsville. She graduated at the University of Alabama and got her Bachelor of Science in Engineering from the University of Alabama. She's a former assistant city attorney. She's been in sole practice for several years and has been practicing law here in Huntsville approximately 11 years, and it doesn't seem that long. I was reading that. It just doesn't seem like it's been that long.
Actually, I've been in practice in Huntsville for 6 maybe, and 5 before that not in Huntsville. That's why it doesn't seem
That's why it doesn't seem like
That's
good. Right. I thought I'd lost about 6 years there. Her emphasis in her practice is on employment law and representing plaintiffs. She's also married to Dr. Johnson Riley and has twin daughters as well as a stepdaughter, all of whom are rising seniors. And I asked her before we started, well, what do they do? And the answer was there's a swimmer, a dancer, and an artist. So the answer to that question is they do everything. And Kerri's in a lot of carpools. The next speaker is John Wilmer. John's been speaking at the People's Law School for several years in this particular subject, and I've always enjoyed it because I've learned so much from this about an area of law that's constantly changing, it seems like. He has practiced approximately 20 years and primarily representing management and labor disputes and employment matters. I might ask him about the baseball strike here in a little while. He's married, has 2 children, ages 8 and 5, and his wife Sylvia practices law with him in the law firm of Wilmer and Shepherd here in town. Finally, the third speaker, who's back here in the back, we've already mentioned he's here. We're privileged to have Judge Joe Battle here tonight. Judge Battle is a circuit judge here in Madison County, was first elected in 1988 and took the bench in 1989. He is a graduate of the University of Alabama Law School and George Washington University. He's got his Master of Law in Labor Law. Before he became judge, he practiced here in the employment law area, representing unions and management and labor disputes. He's married. His wife Janie is a school teacher at Huntsville Middle School. He's got 3 children. Bob, his oldest son, graduated from Yale University and is about to graduate from Vanderbilt Law School. His daughter Kate is a senior at Yale University and is going to attend graduate school at Yale. His daughter Beth is a senior in Huntsville High School, and guess where she's going to school? Yale University and next year. Needless to say, the Yale University Booster Club Huntsville chapter meets at Judge Battle's house. We're privileged to have these 3 folks to talk about this topic of employment and labor discrimination in the workplace tonight. It's a constantly changing area, and I know you're going to enjoy what they have to tell you.
We do have 3 of us up here. There was a sign in my preacher's office over at Trinity Methodist Church that says all of us are smarter than any of us, and that's the theory that the 3 of us are working on here tonight. So we bought 3 of us instead of the one that you had before. My friend Olga Levan, who's sitting out there, and I hope y'all will focus the cameras right over there on that lady on about the 3rd row, said that this was a rowdy crowd and that y'all ask a lot of questions, and so I'm going to start out by asking you a couple of questions. One of the topics that I'm going to cover in just a couple of minutes is terminable at will. In the state of Alabama, you start with the idea that you can be terminated from your employment for a good reason, for a bad reason, or for no reason. And then there are certain exceptions to that that Kerri and John are going to talk with us about tonight in just a few minutes as an overview. Then we're going to get into a hot topic in today's labor law, and that is sexual harassment. If we have time, we'll talk about some other matters such as the Disability Act and some other different things. But let me just take a poll here and ask you to raise your hand in this factual situation. Suppose that you have a hospital employee and that hospital employee refuses to falsify medical records and is terminated, how many think that the employer can get away with that? Raise your hand. Okay, there's 2 people that think that that's okay. The Alabama Supreme Court says that's okay because that person is terminable at will. There's no public policy exception for that person. That person would have to find some statute or constitution or provision or something to protect them. Next question is a trick question. You led up to it and a minute ago when we were having this other proceeding and it dealt with workers' compensation. Suppose that somebody files a workers' compensation claim because they're hurt on the job and then that person is terminated. How many think that the employer can get away with that? Okay. Used to, there was no public policy exception for that situation. That person was terminable at will, but the legislature decided that that wasn't right. So the legislature said if that's the sole reason that you were terminated because you filed a workers' compensation claim, then you were going to be allowed to go to a jury and let them decide whether or not you should be terminated or reinstated. Then there's a situation where somebody was serving on a jury, and when they got back, the employer said, well, that was your public service. You were serving on a jury, but we needed you on the assembly line, so you're terminated. How many people think you can get away with that in Alabama? 1, okay. Used to, that person that was terminated when they came back just had to hit the street and find another job. The legislature said by statute we are going to allow that person to go back to work if those are the facts that are made out. So those are some of the things that John Wilmer thought he was going to talk about, but that's why he keeps looking over here at me on the side of it.
No, that was Kerri's stuff. She was going to talk about that.
In any event, John is going to talk about other statutes such as the Civil Rights Act, Title VII, National Labor Relations Act, perhaps OSHA, age discrimination, and constitutional rights such as freedom of association and freedom of speech and due process. And those are ways in which you can be reinstated if you can win your case, even though you are in a terminable at will state such as Alabama. There are rights that employees have that arise out of limited duration contracts, where you make a contract with your employer for a set amount of time. And there are rights that arise out of contracts that are for lifetime, if anything such as that exists in the labor law world. There are employer handbooks, and there are union contracts. And these are all situations where employees have particular rights that take them out of the terminable at will situation. So Kerri Wilson is going to talk about that, and then John Wilmer will talk. Kerri Riley is going to talk about that, and then John Wilmer will talk about the statutes. First, we're going to hear from Kerri. Kerri?
Okay. And you covered what I was going to say, too. Thank you. I'm not sure I have a whole lot more to say than that. If any of you work at a large employer and you have an employee handbook, most probably at the beginning of your handbook, it will prominently say, this is not a contract, and this handbook does not constitute an offer of employment. There's a reason for that. And the reason is that several years ago, there was a case, Hoffman-LaRoche, for anybody that's taking notes, that found that in certain circumstances, an employee handbook without that type of disclaimer in it can constitute an offer of employment to the employee, which, if accepted by the employee coming to work, can guarantee that employee contractually certain rights that could be found in that handbook. For example, a disciplinary plan that provides for progressive discipline in certain steps. And if the employee is then terminated without following those steps, well, the contract's been breached, and guess what? Employment at will doctrine has been set aside. So that is why you will see in most employee handbooks now a disclaimer. Occasionally you see one that's not there. But that's one way around employment at will. Some other examples of contractual ways around the employment at will doctrine are an offer letter that sets forth, for example, a certain amount of time that we expect for you to work for us, so many months or so many years. The lifetime employment cases, you'll have employment with us until you're 65, and so long as you do a good job or whatever. Some of those cases, in some circumstances, can give rise to an oral contract, or in the case of an offer letter, even a written contract. I was talking with John yesterday about it, and he said that even a probationary period where it's set out that you will work for 6 months for so much and then you'll get a raise, after that, could possibly give rise to a contract that you're planning on working for at least 6 months there. And it particularly comes into play when people are offered employment from out of state and rely on it, sell their houses, move their kids, and come down, and are told, whoops, we don't have that job for you after all. So those are the times when you see these cases coming up, and those are some of the ways that plaintiffs have successfully found their way around the employment at will doctrine on sort of a contractual theory. But of course you have to look at each case separately, individually, and according to each set of facts, as Bo was telling you earlier tonight. And then, of course, the other one that Judge Battle mentioned was union situations, and I won't get into that. That's very complicated, but that is, of course, another contractual way around the employment at will doctrine, and there are lots of steps and procedures and protections built into those kind of contracts.
I'll just say one thing. I don't think anyone said it yet, but you all feel free to ask us questions during the time we're talking. I think it'll enhance your enjoyment and it'll make it go faster, and I hope we can answer them. In addition to the exceptions that Kerri mentioned, there are numerous protections for employees under federal statutes. There are so many protections under federal statutes for employees that the exceptions practically swallow the rule and make employment at will a misnomer. And I'm sure you're familiar with most of those. They include race, religion, color, sex, national origin, age, disability, family leave, and just too many to mention. Garnishments, bankruptcy. I mean, all of these federal laws provide protections for employees. In addition, government service employees usually have some kind of constitutional protection. They have property rights in their job. They have state laws and they have federal laws that protect their job and give them causes of action and guarantees of due process and just cause. So, show me a lawyer that can't find a cause of action and I'll show you a bad employment lawyer. There's usually some kind of cause of action for just about anybody. Some cases are better than others, some cases are horrible, but almost anyone can articulate a cause of action. For businesses, our firm represents businesses, and I would say that if anybody is out there from a business perspective thinking, instead of thinking, how can I sue my employer, thinking, how can I defend myself, my advice is before you terminate somebody, call a lawyer that knows how to handle employment situations. Get advice before you terminate somebody. It'll be cheap advice, and it may save you a lot of grief. Yes.
It raises a question about disputes that might occur regarding whether or not somebody quit or whether or not forced to quit? I mean, to what extent does an employer have to go to prove that the individual, it was the individual's initiative and intent to leave the job and not something done on the employer's part?
Well, I'll do that since I was talking. I'll try that. First of all, there has got to be a cause of action. If it's in the at-will context, the employee can be fired for any reason. But if there is a cause of action, and if the employee is engaged in some kind of protected activity, the employer has to prove that he or she made the decision based on a business reason rather than an illegal reason. And your question raises another point. If an employee is forced out of a job because of intolerable working conditions, that possibly creates a cause of action for constructive discharge, even though the employee was never terminated.
I was sort of couching it from the employer's perspective, though. How does the employer protect himself from the employee claiming that that the employer created an intolerable situation which forced them out? I mean, I'm sort of saying, how does the employer make the case to whomever he needs to make the case to, whether it be workers' comp folks or unemployment folks or whomever, that this was a decision, a free decision on this individual's part to leave the job, and it wasn't anything I did?
Well, I could spend several hours answering that question, and so could these two also. But the best way to protect, for an employer to protect himself or herself, is to have policies and procedures that spell out what an employee can do and what an employee can't do, and how certain situations will be handled and how certain things will not be handled. Obviously, those policies and procedures should have a disclaimer that says this is not a contract. But the employer, if the employer lays out the ground rules for the employee and the employee violates the ground rules, that is a very strong indication that the discharge was for a good business reason rather than an illegal reason.
One thing.
Go ahead.
One thing that I would not want to see if I were evaluating a case, and of course, obviously, policies and procedures and that sort of thing are your first line of defense, but one thing that I would not want to see if I were evaluating a case would be a letter written to the employee after they quit that said, "We're so sorry that you decided to quit your job, and we would have loved to have had you stay on, and you've chosen not to do that, and you know, if there's anything that I don't know about this, you know, call me, and here's my number," and whatever, you know. And I would look at that and go, well, you know, did you call them? Did you tell them it was because so-and-so was doing this? That would just give me pause in evaluating a plaintiff's case if something like that were there. No guarantees, but you know, it's not a bad thing to do, I don't think.
In a very common for employers, they go off with a statement whether kind of promote or leave. And at will, I can accept that, because employer can lay off an employee for any reason. Don't like the looks or whatever, personality, whatever. But if that statement is made, your services are no longer required, and then a week later, someone is hired to replace your position with the exact same skill, is that an argumentative situation on the employee's standpoint, that he was wrongfully terminated?
If the person is young and the person being laid off is old, or if the person, by old I say over 40, if the person laid off is black and the person that is hired is white, those raise inferences of discrimination.
Okay.
We're going to get into a particular topic that is in that area that you raised, and that deals with sexual harassment in the workplace under Title VII of the Civil Rights Act of 1964. The last figures that I have are from 1993, and they show that there were 12,000 claims filed with the EEOC in 1993 based on sexual harassment. To give you some example of types of cases that are going on, there's a case where 6 former waitresses at Hooters filed a lawsuit saying that their employer was fostering an atmosphere in which customers are encouraged to make unwelcome sexual comments and advances toward the female employees. There was a judge in New York who subjected a female employee to sexual touching, crude and suggestive comments, and was removed from office. And then there are people like Supreme Court Justice Clarence Thomas, Senator Bob Packwood, and President Bill Clinton that have been in the news. So tonight we have 2 experts here, one on either side of me, and they're here to answer whatever questions that you have in this area and some other areas. We're going to start with John Wilmer, and I'm going to ask him to give us a working definition of sexual harassment. Feel free to interrupt these lawyers at any time because they're used to it.
Especially by judges. These are what the regulations say, and then I'll give you my own definition. The regulations define sexual harassment as unwelcome sexual advances, requests for sexual favors, or other physical conduct of a sexual nature when submission to such conduct is made a term or condition of employment. Submission or rejections is used as a basis for employment decisions. Such conduct has the purpose of interfering with the individual's performance or creating an intimidating, hostile, or offensive work atmosphere. 2 key definitions. One is what's called the quid pro quo definition, which is if you'll, just to by analogy, if you will go out with me and go home with me, I will make your job easier. I'll give you a promotion or a raise. The other is the hostile sex atmosphere, or the offensive work atmosphere theory of Title VII, hostile work environment theory. And sex harassment, I just want to say very quickly, is a very misunderstood subject. It is, a lot of people don't understand that a small gesture of friendliness is not sex harassment, even if it's misperceived by the employee involved. And we are talking about the employment relationship. We're not talking about relations between individuals. My definition is that such a gesture has got to be, and this is based on cases, and it's just kind of my own checklist, it's got to be severe or pervasive. It's got to be unwelcome. It's got to invoke disparate treatment. In other words, men have to be treated differently than women in this regard. A boss can't treat everybody like hell and still the person claims sexual harassment. The person cannot be receptive to the pass or to the sexual advance. It is typically studied on 2 basic tests. One is a subjective test, and that is the unwelcomeness test. That is the plaintiff saying, I didn't appreciate that remark. But it's also based on the objective test, which is the reasonable person test. It's got to be offensive, abusive, severe, or pervasive to the average person in the community. In other words, you would have to be offended by such conduct for the conduct to be actionable. That's my definition.
They say in the basketball world, no contact, no foul, but it sounds like from what John Wilmer says that there may be more to it than that. Kerri, how do you evaluate a sex harassment case when it comes into your office?
Well, before I answer that, I'd like to say that I generally agree with what John says, but not entirely. I do think there are some instances which can be bad enough that a single instance might be a sexually harassing instance rather than a pervasive pattern. And the bad boss scenario is sort of hotly in dispute, hotly debated right now, whether or not you, in a situation where you just have a hideous boss. And some of us may know and have experienced that. You don't have to name names, but they're so horrible, and the argument is that because of the position of women in society and their socializing and environment, that they take the comments and abuse more to heart than the men do, and therefore, while it may not be actionable on the male male worker's part, it might be on the female's part, and we're talking about not specific sexual things, but just general abuse and harassment. And that was a real hot topic of debate at a recent seminar that I was at. So after having said that, I'll answer the question the judge asked me to answer, which was, how do I evaluate a case? The first thing I do is I look at a plaintiff, the person walking in the door. I look at them, I talk to them, I get a feel for who they are, if I possibly can. I'm looking for someone who can articulate why they feel that they have been subject to sexual harassment. The folks that call, and I do have some of those people who call and say, you know, you want to make $1 million on this case or whatever, you know, nah, they don't get an appointment, needless to say. Are the ones who say, you know, I've gotten fired, I want to sue. You know, they don't get an appointment. Are the ones, many of the ones who call me 5 minutes after they've had the adverse employment action and they're hot and angry and whatever, I usually let them cool a little bit. But the people that come in and are deliberate and considered and are able to articulate why they feel that they have been sexually harassed, who are prepared with names and dates and places, perhaps they've kept a calendar of events, those people get my attention. I feel that they're credible. So that's probably the first thing that I do is I look for credibility. Then I start looking for ways to corroborate what they're telling me. Swearing matches, I've always heard it said, of course, in any lawsuit, the plaintiff bears the burden of proof. And whenever you're talking about a swearing match, this one says this, this one says this, the plaintiff loses because they bear the burden of proof. So I look for something a little bit more than, you know, than that she said he did, he said he didn't. Or in some cases, and I have had cases like this, he said she did, and she says I didn't. And that I think will happen more and more as women ascend the ladder. It's not commonly thought, but sexual harassment can be women harassing men. And I have had more than one case of a younger man coming in and saying, my boss, you know, who was a woman, is saying and doing these things. So anyway, that, I hope, I don't want to talk too long. Yes?
Your discussion about the seminar you mentioned. Mm-hmm. The French philosopher said a few years back that I would happily accept that women are my superior if they just quit trying to be my equal. You know, and this happens in
I'll take that.
And in the workplace, the women will say, or in some cases, that they want to be treated the same way as men. Well, if an employer tries that, then frequently he might get in trouble. You know, says, well, you shouldn't treat me, I'm a woman, I should be treated different. I'm presenting a scenario. In a case like that, I mean, what, you know, if you're all going to be treated equal, all on one plane, then I would think, personally, that everyone would have to accept that same personality and so forth, a directive, work requirements and so forth that an employee would demand. Is that, does a woman have a case that says, I should be treated same as men, equal pay for equal work, but I should be treated differently because I'm a woman? Like men can say, well, they might work 10 hours a day, 7 days a week because they can physically do it, and the woman says, I can't physically do that. Is that a case for harassment on the job?
I think you have to look at the gender situation. If you have something that, like a Playboy or some kind of mechanics calendar or something on the wall, or some pornographic material or something at work, that might not offend some of the men, but it might offend some of the women, and so there are different sensibilities here, and I think that's part of what John was talking about. But one question that we have to cover tonight is whether or not sexual harassment can be consensual. That is, back to the Hooters example, do the women that hire on there in effect assume the risk of that work environment or whatever? And so, if you will, take a minute.
Yeah, but I want to take a crack at his question first. I think that these laws are based on equal performance for males and females and equal abilities, and when those facts are varied, then discrimination becomes less likely. When you've got two employees equally qualified doing the same job, apples to apples comparison, discrimination is easier to prove. When you've got disparate qualifications or disparate performance, it becomes problematic. Let's see, what's my question? Oh, consensual things. This is a little misunderstood. Sex harassment cannot be welcome. A sexual advance, an adverse sexual advance cannot be a welcome to be actionable. It must be unwelcome. However, consent can be obtained by trick, by coercion, by fraud, any number of ways. And a person can be pressured to have sex just like a person can be pressured to do any number of things. So if it is completely consensual and completely welcome, it's not actionable. But if it's coerced, it can be actionable.
How about consensual with the third party?
Excuse me?
The boss.
Okay.
You're in the wrong place. Down the hall.
The boss is taking one of the ladies in the typing pool out, and one of the other ladies is upset about it. Or one of the men is upset.
That's a problem.
Yeah, that is a problem, but I don't think that's actionable.
Oh, I disagree.
I think there are cases, and Kerri's obviously in disagreement with me, but and I'm not condoning this, mind you, but there are cases that say that the male boss that favors the pretty woman over the not so pretty woman, or that gives special job favors to the more attractive woman or somebody he happens to like or is going out with as opposed to someone else is not actionable. Now that's terrible.
She got a promotion as a result
of her relationship with the boss. It's a terrible practice. It's a bad management practice. I strongly condemn it, but I don't think it's actionable. Kerri, what Kerri's response?
Well, I have not specifically researched this, but I believe that I have seen a case that says that that sort of thing could be actionable, and if anybody walks in my door tomorrow, I may have to eat my words and go look up the case, but I would make the argument that the woman who's, and we're assuming that sleeping with the boss has made sleeping with him a term or condition of employment. In fact, in order to get the promotion, you have to be the one sleeping with him. So the poor lady who's not you know,
Those weren't the
doing
facts
that isn't going to get her promotion. And that would be the argument that I would make, that that is in fact an actual situation.
Well, I agree with you
So,
in that situation.
yeah.
If he is coerced it and the person that he's coerced.
Party bring the action.
Right, the one who
I don't
didn't
think
get the
the third
promotion.
party's got a cause of action. The third party, I don't think has.
I do, but I could be wrong.
That's a good case for that. It's a good situation to argue in court, right?
Yeah.
All the people sleeping with each other sound like Hollywood to me. And
We should have had a rating.
we don't see a lot of lawsuits coming from there.
I'm sorry.
We should have had a rating on this program tonight.
This guy over here.
What's the remedy in this case, though? I mean, the individual makes, goes to court, proves that the boss is being sexually harassed, is sexually harassing him, or whatever the case may be, and they're sued, and the suit goes through, and somebody gets a bunch of money. The simple fact of the matter is, if that's a practice that's going on in that particular business, and let's say, just for argument's sake, the business owner owns that particular business,
The remedy's a reinstatement with back pay, and you can have a, why would they go back to that?
Why would they want to willingly go back and say, okay, yeah, I know the guy was, an SOB here, but what I want to do is go back to work for him and get some more money? I don't understand that.
There's also a provision for up to $300,000 of punitive damages that might help them find another job somewhere. That depends on the size of the employer. That is not available if arbitration is the forum, and arbitration is the forum in a union context. And then there's also a section 118 of the Act that refers to arbitration, so that if an employer were to craft an agreement carefully, they might have their employees consent to arbitration, and then they may be, the employee may be bound to arbitration proceedings.
I'd like to jump in here. I think the arbitrator would have the right to give the same remedies that the court would, but I think as a practical matter, the court, boy, am I in trouble here? I'm contradicting it. Not smart at all.
Fine here.
I think if an arbitration agreement precluded the arbitrator from giving the same remedies as a court, it would be it would violate Title VII and would not be deferred to arbitration. But I think that if it did give the arbitrator and the agreement were enforceable, that the arbitrator could give all the same remedies.
There are two responses I have to that. He's told you what he thinks.
I am in deep trouble here, I'm telling you.
And you heard this last hour that that's not admissible. And then the second thing is that the material I have says that that's still a developing area of the law.
Yeah, no question.
Is there such a thing or situation where you can have sexual harassment at the hiring level?
Oh, yeah.
Sure.
Legally,
Sure.
that would be, I hired this person because, male or female, doesn't make it. They hire this person because, she's
Just like age or
amenable
race,
or whatever.
national origin, it's all the...
No, I'm talking about sexual.
Right, I'm saying it's the same. You can have discrimination there, at the hiring level, just like you can with the other elements.
You have a
We had
question?
another question.
How do you prove unwelcome? The word unwelcome, how is that documented?
That's the subjective test.
Yeah.
The person testifies that it was unwelcome. Now, that is subject to a jury's objective consideration of whether it was objectively abusive or severe or pervasive.
Whether it was documented or anything like that, or?
That's just a means of proof, the documentation.
Sort of brings up the situation where you see cases often where there's a lone woman in a group of men, and there's rough talk and tough talk, and she participates in it and later complains that that was unwelcome talk. And there are numerous cases, and they sort of come down either way. It's very developing and disputed about, she says, well, I participated to make so that I would fit in, but I didn't like it at all, and I just had to do this because, otherwise I would have been excluded. And of course they say, hey, she was right in there with us, and she liked it. So Unwelcome can be a real touchy situation.
And take that a little bit further. We're talking about employer, employee. What about co-employee? I mean, there's sexual harassment on that. And what kind of remedies are there for those kinds of actions?
Same.
Well, the remedies are the same.
Against the individual?
No.
No.
I'll try to handle that. That a co-employee situation can create only a hostile work atmosphere type theory. And the only way a hostile work atmosphere theory can be maintained with a co-employee or with a management employee doing the harassing is that it's got to be an unwelcome sexual advance, and it's got to be reported to management. There has got to be respondeat superior. There has got to be agency proved that links the employer to knowing this occurred and not doing anything to resolve it.
There's an Alabama case on that where the judge threw the case out. It went to the state Supreme Court, and the Supreme Court said that it would go back and be for trial. And they said that the employer, in addition to the employee, could be liable if the employer knew or should have known of the sexual harassment and knew that it was wrongful and continuing and failed to take adequate steps to remedy the situation. If the employer stops the conduct as soon as it can, finds out about it and so forth, then as a matter of law, the case law says that the employer is not liable. We had a Madison County case that was in my courtroom that involved Kroger, who settled out of court, and then the Kroger employee was sued, and the issue was whether there was sexual harassment or not when a lady standing up on a stepladder was told by somebody that was a co-employee, come on down and you can hug and kiss on me all you want. This was his second or third attempt. I guess they were all unsuccessful from best we could tell in the jury trial. But in any event, the jury, for whatever reason, found for the defendant, and there was no recovery for the plaintiff except for the fact that the Kroger company was concerned enough with the case and with the aspect of the jury trial and the past practice, this particular employee, that they settled on a nuisance basis out of court. So these are situations that occur right here in town and all around, and the question that I have for Kerri is, if you find yourself in this situation, what do you do?
And my answer is report it. Report it, report it, report it, and get your calendar that you keep on your magnet to your refrigerator, or you keep in your pocket or your day timer or whatever, and write it down. Whatever day it happens, whatever time it happens, whoever was there, just keep some little notes. Document. Do both things. And if you're not satisfied and it doesn't stop, then of course get legal counsel right away, because you do have limited time periods to take action.
Is there some sensible limit in this? Girl comes to work in a miniskirt and a low-cut dress and wiggles up and down the halls, and the men's eyebrows go up and down, and she sits writing this up. Does she have a legal complaint to her employee that, you know, they're looking at me in ways that are unacceptable or something?
Well, the limits are reasonableess. Okay, I actually wrote down. John copied the definition of sexual harassment, and I have the same thing here, but I copied the examples. And number one was leering and ogling. Can be. We actually couldn't figure out how to pronounce ogling, so my paralegal, who is male, and I had a long discussion about what was ogling, and all we could figure out was, you know it when you see it. You know? So.
The information I read called it elevator eyes.
Yeah. But whether or not it would be reasonable for the gentleman on the job to ogle the young woman who wore the miniskirt up to here and the dress down to there, I guess would be up to a jury to decide.
I have a question. Scenario, an office of females one who does not participate in the naughty joke type telling, does the one who is offended have an action against those others that's maybe disturbing her work or this type of thing? That would be a female offended by females, or vice versa with me.
I have not seen or heard of a situation where female on female or male on male can be actionable under Title VII, and maybe John will have a comment on that. I do believe that in the situation of sexual advances by a person of the same sex on a person who is of not that persuasion, I do believe that that may be actionable. But just the dirty jokes and the woman who, you know, all the women telling dirty jokes and the one woman who, for whatever reason, has finer sensibilities than that, I do not believe that's actionable. John, do you?
That may be advanced level material that we'll have to come back to.
Thank you, Judge.
I can't go to the lounge because I'm denied that because of my beliefs of this type of thing. I just wonder about it. I mean, I'm not talking about me personally. I'm just saying the individual.
I think there might be, if you read the regulations as they're written, verbal conduct that has the conduct of the effect of interfering unreasonably with the individual's work performance or creating an intimidating, hostile, or offensive work environment. I don't think that part of it would be restricted to males versus females. Now, Kerri's right that a homosexual advance would not be protected under this statute, but I think a hostile work atmosphere, if the employee complained about it and the employer didn't do anything about it, I think that might be protected.
That brings us to the equal time here in the Kroger situation or whatever the situation is. What does the employer do when they discover that there's a claim that's floating around out there?
Well, the thing the employer does is investigate and do a prompt remedial, take prompt and remedial action if the circumstances require. The first thing I would do if I were an employer is I would have a sexual harassment policy, a policy that forbids sexual harassment and establishes a complaint procedure that gives employees a vehicle to complain internally about it and not go to the courts and not go to the EEOC with such a claim. If the employee fails or neglects to do that, they are generally precluded from having a cause of action if there is a complaint procedure in existence. The investigation that the employer should take should be a very thorough investigation and not a whitewash. The investigation should be one that is done in good faith and as done on as neutral fact-finding basis as possible. If discipline is required, the employer should take discipline. And the employer should not whitewash it because the manager happens to be a friend or the manager or this person happens to be a valuable employee. If discipline is involved, it doesn't mean the person's got to be terminated in all circumstances, but strong, prompt, remedial type action should be done. The other thing is employers should be very careful to prevent retaliation. Retaliation is the thing that can happen the most frequently. Even if there is a bad complaint about sexual harassment, one that is without merit, if the employer retaliates against the employee or the supervisor retaliates the employee for making the complaint, there is generally going to be a cause of action.
One thing I wanted to respond to this lady a little further. Regardless of whether there might be an action under Title VII, and we haven't gotten to this yet, but we should because we're running out of time, there are state law, Alabama state law claims for such things as intentional infliction of emotional distress, where after you've complained perhaps and said, this offends me, and there's continued comments, that may be intentionally inflicting emotional distress on the person, or invasion of privacy. You know, comments, come on, tell us about whatever that you might consider to be private and personal. There are state law actions for such things as those. Outrage is, of course, another potential. So.
And along those lines, there was a Florida case in 1992 where a jury awarded over $1 million in a situation where assault and battery and outrage and intentional infliction of emotional distress and invasion of privacy were alleged. So, like Kerri says, there are state actions in that area. We do have about 15 minutes left here, and we're going to try to cover something other than sexual harassment, but we've had a very patient man there in the back.
Is there a statute of limitations on when they can file for sexual harassment?
Yes. Generally speaking,
What was the question?
time limits, statute of limitations. Generally speaking, you must get your claim into the EEOC within 180 days of the adverse employment action. You know, if you're bringing a state law claim, then those are 2-year, generally, statute of limitations. Occasionally, in certain circumstances, someone else may perhaps have filed a claim and you can piggyback, or there may be continuing violations so that you can, all may not be lost, but you must always strive to get your EEOC charge in and filed within 180 days. Because you are generally barred if you do not from filing a lawsuit.
If I'm a witness to an incident where a person was sexually harassed, would I be, is that now reporting as breaking the law in some way?
I can't see that you would be breaking the law. This was another hot topic of debate at the seminar that I recently attended, because often what happens is in this investigation that John was speaking about earlier, employees have seen and heard things, and they don't really want to get involved. So no, they're not breaking any law that I know of. If you fail to answer your employer's questions, you could be insubordinate, which would be grounds for termination, even though we know we have at will, so you don't have to have grounds. But often employees have, I think, a fear of being the one, shoot the messenger. You know, if they're the one that provides the corroboration to what this complainant is saying, they're afraid that they're going to get shot. And I don't know of any protection that that employee would have.
Are you a supervisor? Are you asking that question as a supervisor or as a co-employee? Okay.
Yeah, as a co-employee. As supervisor has totally different obligations.
Speak to that ratification and condemnation.
Yeah.
If you're a supervisor and you see that you should be under instructions at your place of business to report the conduct and to pass it up to management, because you're seeing the conduct and accepting the conduct is possibly going to be taken as a condemnation or a ratification of the conduct, and would prevent the would keep the employee from having to make the complaint to the supervisor in the first place if the manager or supervisor has seen the conduct in the first instance.
Are there any other questions in this area before we leave this and go on to Americans with Disabilities Act?
How about outside parties like UPS and Airborne? Do they run in the floor with receptionists?
The employer has an obligation, I believe, to provide a harassment-free workplace. And they have an obligation to protect their employees from vendors coming in and doing that sort of thing.
But the employer has to know about it
Right.
in order to protect it. If the receptionist just suffers in silence and never says anything, or the boss or management doesn't know that it's happening, then it wouldn't be actionable. But if he does, if the boss knows and tolerates it, it very well could be.
A good plaintiff's lawyer might sue where they work and also sue UPS. With that, we'll move on to the American with Disabilities Act. Just in a sentence, the ADA prohibits employers from discriminating against a qualified individual with a disability in all aspects of the employment relationship. This act was passed in 1990. It's sort of like Title VII of the Civil Rights Act, except it applies to disabled Americans. So that jury trials are available, compensatory and punitive damages are available under the ADA, just like under Title VII. With that, John, give us a definition that's a little more proper about what disability is under the ADA.
Okay. Disability is defined under the ADA as a very broad definition. It's a physical or mental impairment that substantially limits one or more of the major life activities of the individual, a record or of such an impairment, or being regarded as having an impairment. And all of those are very broadly framed. For instance, the physical or mental impairment can be a physiological disorder, a mental or psychological disorder. Major life activities include caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. All of those things impairment, a permanent type of impairment creates the inference of a disability. And discrimination against a qualified individual with a disability is actionable under certain circumstances under that law.
Kerri, tell us, under the law, how far from an employee's viewpoint the employee can expect to be reasonably accommodated.
Well, reasonably accommodated contains its own definition. It has to be reasonable. The employee should take it upon themselves to figure out what they need in the workplace and to ask the employer for it. If the employee themselves can't figure out what they could do to be able to do this job reasonably, that may answer your question right there, but they should do that. And a smaller employer is going to probably have to go less far than a very large employer. An employer with essentially unlimited resources, what's reasonable for them may be a long way down the path, a public employer, for example, as opposed to a small employee. So it's going to be very, very fact-specific. But many times it's really a relatively small thing that the employee really wants. And if they articulate that and the employer isn't willing to do that, I think the employer has a real problem.
At the courthouses, some thought that jurors who are blind or who are hearing impaired should be accommodated. There's a requirement on the books that says you have to be able to read, write, understand the English language so that you can review exhibits in the jury room, and we've had instruction that we need to accommodate folks that want to serve on juries who have disabilities. But how far do employers have to go?
The level of no return is undue burden or undue hardship. And as Kerri was just saying, undue hardship is a fact-specific determination. Now, let me digress a minute. We are talking about probably the two biggest, hottest employment issues going right now: disability, sex harassment. In my office, those two issues really dominate the calls we get and the issues that come. So we're not just choosing Americans with Disabilities Act and sex harassment at random. They are really things that people want to know about. But back to your question, Judge. Undue hardship means a significant difficulty or expense incurred by the covered entity. And as Kerri said, the test is a sliding one based on the size of the employer and the type of accommodation that's required. And that's about all that I can tell you without getting into a lot more detail.
Let me just add, I know we're running late, and we had promised everybody that we wouldn't, but we had 3 speakers and a lot of questions, and I wanted to prolong this. I think if I can ask the participants here to stay a little bit and answer some more questions, and maybe just sum up, and so we can let these folks go in, because we did promise them we wouldn't keep them too late, but I know we've had an awful lot of questions that's prolonged this, and I wanted to get everybody's questions involved.
We'll just sum up by saying we'll be in recess until your next meeting.